The Alice Magistrates Court, sitting in Dimbaza in the Eastern Cape, has now released 10 more of the people accused of being involved in corruption at the University of Fort Hare. The NPA decided not to oppose bail for the 10 people. It is still opposing bail for 3 others of the 15 people who were arrested over the Easter weekend in connection with the alleged corruption. The state says it will oppose bail for Terence Rabea, Anwar Khan and Isaac Plaatjes. One of the people then released on bail is a lawyer, Bradley Conradi. He's being represented in court by William Booth from William Booth Attorneys. William, good afternoon to you and thank you for your time. I presume you're quite pleased that your client is now free on bail.
Yes, absolutely. Good afternoon, Stephen. It's certainly been a hectic 2 weeks. Bradley and his forensic assistant were arrested just before Easter, kept in custody. She was released last week on 50,000 rand bail, and Mr. Conradi was released today on 50,000 rand bail. There were a few others as well that were released. We've lodged, certainly on behalf of Bradley, very detailed representations last week after the case was postponed, pointing out why he shouldn't be kept in custody any further. The state then came back to us the day before yesterday to say they were no longer opposing bail. In fact, we tried to get him out yesterday, but there were some logistical problems to get him back to court. But he was released eventually today, and he's on his way back to Cape Town.
You had previously said that a previous ruling by this court that it does have the jurisdiction to hear the bail application was incorrect. Are you still going to appeal that, or does that now all fall away because of how things have played out and the fact that your client has been released?
Well, to an extent it has fallen away. I'm not saying it's an aspect that we can't raise later, because the warrant of arrest that was authorized by a magistrate in East London stipulated very particularly that he should appear in East London Magistrates Court A. Instead of that, they took him to Dimbaza, which is out of the magisterial district of East London, because the allegation was that this offence was committed in East London Magistrates District, and in fact the police case number originated from the police in East London. So that a lot of time was spent last week arguing that point, and the upshot of that was, if the court had agreed, then all the accused would have had to have their cases struck off the roll, and they could have then been released from custody. The magistrate found, and I still believe it was incorrect, that the Dimbaza court did have jurisdiction, but that in a way, as I said, it's pretty much fallen away now that he's got bail. It is a factor that one could raise later on, but I think the more important aspect is that the search warrant that was issued by a judge in the Eastern Cape allowed for a search in other cities in this country. In fact, in KZN, in Gauteng, as well as Cape Town. So a judge or a magistrate can't issue warrants out of the jurisdiction of their particular area. So that was done, and that is certainly an aspect we will be dealing with later, when the trial should take place. But I have concerns about warrants of arrest being issued when circumstances should first be checked, whether it's necessary to arrest anyone. The speaker was released on bail. She reported to the police station and went straight to court, and bail was unopposed. That should actually have happened to Mr. Conradi and certainly some of the other accused in this particular case. And the same with the issuing of search warrants. There's a law that governs when a search warrant can be authorized for which area, because it is a serious invasion into the privacy of somebody who has their offices searched as well as their private homes. But the search warrant is certainly an important aspect that will be dealt with at a later stage in this case.
I'm sure the NPA will oppose anything like that, and it'll be up to them, but it must have happened many times in our country that search warrants have been exercised involving a group of people in different parts of the country all at the same time. I mean, are you saying then that you'd have to go to a judge in each major city or each jurisdiction, each magisterial district, for each of those search warrants?
That is so, because you've got the search warrant is governed by the Criminal Procedure Act, and there are cases going all the way up to the Constitutional Court that set out the criteria for search and seizure, because it's an invasion of one's privacy. Police suddenly arrive at your house, they want to search. You might be totally and utterly innocent, or arrive at your office or at your studio, Stephen, and want to search the studio. So, the courts have got to jealously guard the Constitution and the rights of people. But the Criminal Procedure Act says that a court or a magistrate who is approached for a search warrant, or a judge for that matter, can only issue warrants in their jurisdiction. So magistrates have let's say, a lesser jurisdiction than a judge. So a judge in the Eastern Cape can issue a warrant for anywhere in that area where the High Court has jurisdiction. That's a wider area than, let's say, a magistrate in East London who's issuing a search warrant. He can only, or she can only issue for East London, can't issue, let's say, for Dimbaza or other parts of the area. But a judge who is sitting, let's say, at Bishu, can issue a search warrant for a far wider area. But they can't issue search warrants for KZN, for the Western Cape, Gauteng, or the Northern Cape, for example. That falls outside of the jurisdiction of a magistrate or a judge in the Eastern Cape.
As I understand it now, I don't know if the NPA has made this claim, but I think there's been public comments from the current management of the University of Fort Hare that basically a group of people came into the institution with the intent to steal money corruptly from it. Your client's been arrested, now released on bail as part of this. At this stage, do you know if your client is going to plead guilty or not guilty to the charges that will be brought against him?
Well, Stephen, can I tell you, the whole way this case happened is, my view, completely irregular. My client and one of the other co-accused were involved at Fort Hare to investigate corruption. They had actually unearthed millions and millions of rands worth, if I can use that word, of corruption, that people were appointed incorrectly. They were dealing with disciplinary action against people who were wrongly appointed. So that was their involvement. They were in fact approached by prosecutors and police of the Commercial Crimes Unit in East London to assist them as witnesses, because that is exactly what they were. Then suddenly another unit, the Anti-Corruption Unit, and most of the police in that unit are stationed in Gauteng, they then are involved with their arrest and with the search of their properties. So you've got two units of the South African Police Service at loggerheads. The one says, well, we want to use you as a witness. The other says, no, we want to charge you as an accused. Okay. I mean, that really doesn't make any sense.
Right, I realize it's your job to represent your client, Mr. Booth, but we have seen also in the case of Isaac Plaatjes, who presumably had been sort of on the side of against corruption, held a position in which he was supposed to be against corruption, but has been arrested too. What I'm trying to get to is the situation at Fort Hare does seem very complicated.
I'm not saying it's not complicated. I mean, Mr. Plaatjes has been arrested on very serious charges. I'm not saying corruption is not serious. He's been arrested with regard to arranging murders at the university. But I'm saying that my clients were asked to look at issues at the university and went in to investigate and unearth corruption and, in fact, laid complaints with the police against certain people with regard to that. And they were approached to assist the police and the prosecuting authorities to get to the bottom of this corruption. So their case is a lot different to Mr. Plaatjes' case or the others who are arrested for, on the more serious charges of murder, or in fact quite different to some of the other accused in this particular case. You've got to decide, are you going to use somebody as witness because they've unearthed corruption or they have facts leading to serious crime, or you're going to now charge them criminally. So it's, to put those two facts together just doesn't make sense. It didn't seem to me as if the two police units or the two different groups of prosecutors were talking to each other.
William Booth, thank you very much indeed. An attorney at William Booth Attorneys representing two of the people arrested in this case and now released on bail. In a moment.